Hi friends, good evening. Today,
Good evening, Anna.
good evening, ma'am. Today, I wanted to cover life cycle of a domestic violence case, touch upon different provisions of Domestic Violence Act, which talk about the procedure and also what are the reliefs available and what is the way to file it, and couple of my own personal tips that as an advocate we should ensure to take care of. So that I will cover in the next like 5-10 slides. Okay, Priya, let's move to next slide. Okay, we have already discussed about Domestic Violence Act and various situations, even in the group also. Today, I wanted you to focus on these two pictures. Okay, this is statement of objects and reasons. Okay, so what is meant by statement of objects and reasons? Yes, friends. Sorry for the disturbance. What is meant by statement of objects and reasons? Every time a new law is made and passed by the parliament or state assemblies, the minister who is introducing the bill has to give reasons why they are making or bringing that bill to the parliament. What is their intention to solve, what problem they are bringing this new law, or if they are amending the existing law, why they are amending that. For example, I'll take an example of Nirbhaya incident. That incident of gang rape and murder happened in December 2013, I believe, 12, sorry. So in the next 2 months, because of the outrage coming from the public, central government amended CRPC, IPC, Evidence Act to strengthen the provisions. So at that point in time, the minister who is introducing that amendment act explained why they are bringing this change. So for any law, you should find statement of objects reasons. This is a guiding principle. This is a guiding document. So if you read this document for PWDV Act, it gives very crucial information why this act is being made. So let me read out. I will focus more on these couple of paragraphs. Please bear with me. An act to provide for more effective protection of the rights of women guaranteed under the Constitution who are victims of violence of any kind occurring within the family and for matters connected therewith or incidental thereto. So this is a enactment, a legislation targeting to protect the rights of the married women, not married women, sorry, women within a family. For example, if an assault happens on a woman and the perpetrator or the accused person is unrelated, there is an IPC section for that, 323 and so on and so forth sections. But if a violence happens within the family, that means it is a domestic setup, right? That is why for that specific crimes, Parliament has enacted this law in 2005. Okay, let me continue with that. Domestic violence is undoubtedly a human rights issue and serious deterrent to development. So basically it is a obstacle to make any progress because someone is getting someone's rights are getting violated. Now there are certain international conventions they have listed which recommend that state parties, here state means countries, state parties means countries, they should act to protect women against violence of any kind, especially that occurring within the family. So international conventions also categorically passed some directions, conventions saying that you have to make laws in your own countries to protect the women against violence within the family. The next is the phenomenon of domestic violence is widely prevalent, but has remained largely invisible to public domain. If you observe the choice of words, they are saying invisible because there is no law to tackle that. Presently, where a woman is subjected to cruelty by her husband or his relatives, It is an offense under section 498A of the Indian Penal Code. We know this IPC 498. The civil law does not, however, address this phenomena in its entirety. By reading these two to three lines, we should understand that there is a criminal provision to handle domestic violence. The Parliament is saying there is no law on the civil side. So people can be put in jail because of section 498A. But what about the civil remedies? Civil remedies like compensation, protection, shelter, medicines, right? All these things are civil. There is no penal punishment. There is no jail in the civil side. Correct. So Parliament has enacted this PWDV Act only to protect the civil rights of the women who are subjected to domestic violence. This should be a clear-cut, answer to anybody who say protection of the women from domestic violence act is a criminal act. No, it is not criminal act. It is a civil law. Right now, there are some timelines given. I want you to focus on the durations. The bill was introduced in Lok Sabha on 22nd August. Next 2 days, the bill is discussed in Lok Sabha, and after a week time, it is discussed, debated in the Rajya Sabha, and then both Lok Sabha and Rajya Sabha passed the bill on 5th session, and then President's assent is obtained on 13th September. Within a span of like 1 week, 8 days, and here within a span of 3 weeks, this enactment is introduced, debated, passed, and President has given a consent. How much valid or valuable discussion happened in the Parliament? It is documented in the parliamentary debates. If any one of you are interested, you can check out the Parliament website, Indian Parliament website. There you have all the PDFs available, where they have documented what is the discussion question and what is the answer. I'll read the last para of objects and reasons. It is therefore proposed to enact a law keeping in view of the rights guaranteed under Article 14, which is equality before law, Article 15 and Article 21 of Constitution of India, to provide for a remedy under the civil law, which is intended to protect women from being victims of domestic violence and to prevent the occurrence of domestic violence in this society. The Act seeks to achieve the said object. So I think you understood a lot of things in this one slide. There is a statement of objects and reasons, that what is the importance of that document, what does it talk about, and some timelines, and then what is the purpose, why they are bringing that law, to eradicate what problem. Right? Yeah, let's move on. Next slide. Yeah, as usual from my previous slides, I have given a lawyer's point of view, advocate's point of view in this slide. So I'm saying this legislation is a pure civil law, right? But since there are certain things which require criminal procedures provisions, that is why CRPC is made applicable to this law. Okay, but the law by itself is a civil law. There is a provision for penal punishment only on breach of protection order. One of the remedies available in this act is protection order. No one should contact the aggrieved person, the victim person, phone, email, in person, oral. Any way of communication can be prohibited. If someone, a person, accused person, violates that protection order, then there is a punishment of 1 year and 20,000 rupees fine. Other than that, there is no jail punishment or jail term in the PWDV Act. It's a civil law. Generally, advocates can file a domestic violence complaint or application under Section 12 of the Act, or advocate can again file an application seeking interim reliefs, because nobody knows when the case will be, main case will be closed. So applicant can ask for interim release. For the time being, please grant me this release. For example, I am asking 50,000 rupees in my main application, but for the time being, at least give me 20,000 rupees. It will help me. Okay, like that, you can ask for interim release under Section 23 of the Act. Then there are a couple of provisions, one from the same Act, another from the CRPC I am listing, which talk about you have to dispose of the main case, main DVC case within 60 working days, 60 days. That means considering 21 working days in a month, maximum 3 months, a domestic violence case has to be disposed. It is by law. I am not saying this. It is in section 12, subsection 5. I don't think any case, any DVC case got closed in 3 months. That is one problem. But as a petitioner, you guys are advocates, you can write this section. Clearly mention that please dispose of my case within the time limit prescribed under section 12.5. Similarly, section 309 CRPC also prescribes daily hearing should happen in the case. These are rights given to the accused, the victim person. Advocates have to fight for their rights. Daily hearing has to happen under 309 CRPC unless there is a situation which cannot be avoided. COVID, physically sick, court not functioning, judge is not available, etc., etc. Except those very few reasons, case has to run on a daily basis. But that is not happening. You normally get to 2 weeks to 4 weeks of adjournment. If that is the situation on the ground, how can you implement a 60 days time limit, right? So you advocates have to fight for the your client's right. And if you are on the defendant side, respondent side, you can ensure that your clients are not traveling to the court place every day. They don't have to travel because you are representing your clients. You can file a 205 CRPC application and pray to the court that my clients are not the local people, they are outstation, they are elderly people, maybe 60 years or 70 years, they are sick people, they have to travel like 500 kilometers, 1000 kilometers one way. Right. So taking all these inputs, you can ask for exemption. Right. Similarly, if you sense that magistrate court is hostile to your client, for whatever reasons, some magistrates have some prejudices. They have some, pre-existing mindsets. This person is, this male person is always wrong, or female person is always wrong, something like that. If the court is hostile to your client, don't fight with the court. There is no point. The situation will worsen. You ensure that one way or the other, the magistrate passes some orders quickly, maybe 3 months or 6 months. Take that order and go to the higher court. Take the case out of that hostile court. Simple. Right? Once the case is moved out of that court in a revision or an appeal, then if you want to file a complaint against the magistrate, you can file against the magistrate. But don't fight in the court. There is no use for that. If you fight, there is nothing. Your reputation will be damaged that this person talks rudely to the court. So don't do that, or at least to the extent maximum possible, don't do that. And I have given a list of case laws here, and you can go through them if you want. Okay, next slide. Yeah, I will quickly go through the provisions because these are always already there in the Bail Act. You can always refer to these sections in the Bail Act. I will quickly go through these. I will only highlight few things that I wanted to convey to you. Who is an aggrieved person? Any woman who is or has been in a domestic relationship with the respondent. Now, who is respondent? Any male. Sorry, I should have strike off that adult male 2 words in the section 2Q. I'll take it out and share this revised one. So any person, male or female, major or minor, they can be respondent because they could have caused domestic violence against a woman. Okay, this is on the subsection Q, respondent's definition. There is a provisory right below it in a small font. Please read that carefully. Provided that an aggrieved woman or a female living in a relationship in the nature of marriage. Very, very important set of words. What is this phrase means? A female living in a relationship in the nature of marriage. They are not saying in a marriage. If someone gets married, a woman gets married, she is called as wife by default. But this act provides extra facility to people, women, who are not married but living in the nature of marriage. So I will explain to you what is meant by nature of marriage. There is a case law given in the footer of this slide. You can go through that if you want. Indra Sharma versus VKV Sharma. It's a landmark judgment. You can read it at leisurely. It says, if man and woman are living in a single shelter under a roof, their cooking is happening there. They are showing themselves as a couple, not married, but a couple to their surroundings. And if they have, or if they have children together. So if these 3-4 conditions, there are other conditions in the judgment, you can read them. These 4-5 conditions are satisfied. That means that female can file a domestic violence case. She need not be a woman, a married woman. She can be in a relationship in the nature of marriage with a obviously one member in that family. These days, male relationships are also not barred. Female relationships are also not barred. So she can file a complaint under Domestic Violence Act against any person with whom she is having a relationship in the nature of marriage. Because of this expression, DV Act should not insist on a strict proof of marriage. Bring me the marriage certificate, bring me marriage photograph, where is the wedding card, where is the marriage photos? No, nothing is necessary. As long as you can show to the court that we lived in the home, we shared expenses, we had common kitchen where we cook, we used to live in the same home, we had kids also. So any of those things can be proved to establish a relationship in the nature of marriage. So that is why I am taking time to explain to you that particular phrase. And in section 3, there is an elaborate explanation given what is meant by domestic violence, what all comes under domestic violence. It is a very wide explanation. If you switch to next slide, we have more details about the abuse, what is meant by economic abuse, what is meant by physical abuse. Yeah, first one is physical abuse, sexual abuse, verbal and emotional abuse. Right? Since this is a civil matter, if you can convince the court with your pleadings, with your writing in the petition, you may have a chance of winning the case. Strict proof of anything is not necessary. But then that doesn't mean you can throw any allegations on the other side person and expect to win. No, there should be some supporting material, but strict proof of marriage is not necessary. That itself is a little relief to few people, few women in our society. Right? Verbal and emotional abuse. Maybe there is no physical wound, there is no rash, there is no wound. But then because of verbal abuse, ridicules and humiliation, degrading words, commenting on their physical attributes, unable to cook, unable to keep the clean home, unable to give male child. So all these things come under verbal and emotional abuse. Okay, and then the next one is economic abuse. So deprivation of all or any economic or financial resources. For example, you are living in a home and the rent is being paid by the husband or the man with whom the woman is having a relationship. That person stops paying the rent, or you use a 2-wheeler or a 4-wheeler. The man sells that that vehicle away. So taking away any economic or financial resources for which you have a right to use, you don't have to own it, because in a home setup, not everybody will own everything. I don't own the table, I don't own the fridge, I don't own the TV, etc. My father bought it, or my husband brought it, but I have a right to use. If you take that property away from me, that is economic abuse. So they have given detailed explanation. You can go through that. A, B, C they have given. Right? Okay, next slide, please. Now, as advocates, we need to, I told you that we can file application under section 12. We can file application under section 23. One for the main case, second one for the interim release. So this is what the section 12 looks like. So again, here also I have highlighted a few things that I want you guys to understand and focus. An aggrieved person, basically a victim woman or a protection officer or any other person on behalf of the aggrieved person may present an application to the magistrate seeking one or more reliefs under this act. Sandeep is not saying this. Ladies, please understand. This is mentioned in the law. If someone asks you, no, you have to be physically present here, you have to sign, you have to do anything, show them this and say, how do I interpret this particular phrase? Any other person on behalf of the aggrieved person, and take advantage of this phrase. Okay, so I'm giving you hints, I'm giving you pointers. Take some steps, efforts to understand it better on your own. I think that learning will be remaining permanently with you. Next, the proviso, next, right below that, provided that before passing any order on such application, and here if you see, there is no complaint, there is no use of complaint, there is no use of petition. It is being called as application, right? Application, even in the above, may present an application. So these are very specific terms about with respect to this act. We should use the same terminology. Magistrate shall take into consideration any domestic incident report received by him from the protection officer or the service provider. If the protection officer does not give domestic incident report, it is okay to skip that. We have a recent judgment from the Supreme Court. It says domestic incident reports are not mandatory. If the protection officer sends it to the magistrate, consider them. If the protection officer or the service provider does not send the DIRs to the magistrate, ignore that aspect and go ahead and pass orders. Okay, I will skip the next one or two aspects. Please focus on subclause 3 and 4 and 5. Every application under subsection 1 above shall be in such form and contain such particulars as may be prescribed or as nearly as possible thereto. So this act, Protection of the Women from Domestic Violence Act, it came in 2005 and rules were framed under this act in 2006. In the 2006 rules, DIR domestic incident report formats are given. There are 6 to 7 reports. All formats are given. You can take a look at the rules to understand how should I write a domestic DV petition or application. Now, subsection 4 talks about magistrate shall fix the first date of hearing, which shall not ordinarily be beyond 3 days from the date of receipt of the application by the court. For example, one of our colleagues files the petition on 1st June. 1, 2, 3. On 4th, the first hearing should happen. Right? We are 4th or 5th within not ordinarily beyond 3 days. If the petition is filed on 1st, it will be numbered 2nd, 3rd, 4th. Maximum on 4th, the magistrate has to fix the first hearing. What does the first hearing mean? The aggrieved person should come to the court before the judge, and the respondent should also come. But problem is, the respondent doesn't know that there is a DV case on him or his family. So it will take some time because of the postal delays, etc. Currently, we are using postal, register post, etc. to send the notice to the respondent. Boss, there is a DVC complaint against you. Please come to the court. Right. So that is what is written in the law. This law is made in 2005, friends. Remember. The last one I already covered. Magistrate shall endeavor to dispose of every application made under subsection 1 above within a period of 60 days from the date of its first hearing. Obviously, 60 days are working days. We cannot expect anybody to function on a Sunday or a Saturday, non-working day. So 21 days of working days, 60 days, which is 3 months of time. That is why we just now read the statement of objects and reasons. Parliament is clearly aware that by the time the relief comes to the victim person, it is going to take 5 years, 10 years. What is the point of such kind of long proceeding? So they want to give a quick relief to the DV victim. That is why they have set a time limit. Okay. Yeah, next slide, please. Right. After the initial hearing, the notice have to be sent to the respondents, and court will take assistance of protection officer. So the protection officer will send the notices to the respondents. Right. And again, maximum period of 2 days. There are some time limits given. Expecting that courts will follow the timelines. So there is nobody following that. I have a public interest litigation idea on this also. If you are not going to implement the 60 days time limit, take that away. We don't want that. I don't want to see that in the act. Okay, that's the idea. Now, since this is a matrimonial issue, there are bound to have fightings between the family members. It could be wife and husband, or the in-laws and the daughter-in-law, etc., etc., etc. So the parliamentarians are suggesting put the both parties to counseling, not mediation, settlement, etc. Counseling to understand what is the root cause of the dispute. And then if the counseling helps them to sort out their differences, we can stop the proceeding then and there itself, at the counseling stage itself. Okay. Next slide, please. Now, jurisdiction and the next few sections are very important. Where can a case be filed? Okay. The court of judicial magistrate of first class or metropolitan magistrate. Judicial magistrate first class means non-metros, small towns and cities, small towns. Metropolitan magistrate means who is presiding over a city, Hyderabad, Bangalore, Vijayawada, etc. As the case may be, within the local limits of the person agreed permanently or temporarily resides or carries on business or is employed. It's a very wide definition. The victim person could be permanently residing in a particular place. There the complaint can be filed. Even if the victim person is temporarily residing there, for the time being, even there DVC can be filed, or wherever the business or wherever you are performing your job within the territory of that court. In that court also case can be filed. Second point is where the respondent resides or carries on business or is employed. So the case can be filed where the accused person is residing or doing business or employed. And the third possibility is where the cause of action has arisen. For example, the wife and husband live in city number A, city A, but the DV happened in city B. So cause of action arose in city B. So in city B also, even though it is unrelated to parties, wife and husband, even in that place, the DVC can be filed. Okay, and shall be competent court to grant a protection order and other orders under this act and to try offences under this act. So if you see, they are clearly saying reliefs and offences. They are clearly distinguishing two words. Protection order and other orders are reliefs. Offense means a crime. Okay, when can a crime happen in under PWDV Act? When a protection order is passed by a court and that protection order is violated. The court says you should not talk to your wife and the children, and if that husband or in-laws talk to the wife or the children, that means there is a violation of, there is a crime happening there. They are violating the protection order. Okay, so jurisdiction of DV Act is very wide. Next one is procedure. What to follow? Is it a CPC to be followed, CRPC to be followed? What to follow? So they have categorically identified some sections and are saying for these sections, proceeding under these sections and offences, see this, all proceedings under 1, 2, 3, 4, 5, 6 and offences under section 31, clearly distinguishing proceedings which are in civil nature, proceedings which are in criminal nature. Offence under section 31 shall be governed by the provisions of Code of Criminal Procedure, CRPC. Okay, and subsection 2 says if the procedure can, if the magistrate wants, if the court wants to follow its own procedure, deviating a little bit from the CRPC, the magistrate is authorized to do that. There are certain special considerations where a magistrate can apply his judicial mind and follow his own procedure, but not totally deviating from the CRPC. Little bit of flexibility here and there. Okay, and this is applicable to section 12 as well as section 23, ex parte orders as well as main DVs. All right, now the next section talks about, okay, main case is disposed and one or the other parties are unsatisfied. They are not happy with the decision of the court. So they can go to appeal or they can go to revision. We have a judgment which says under section 29 itself, a party can file an appeal or revision. So there is a difference between these two. We'll talk about it later. And what can be appealed, what can be revised? Any order. Any order. It can be a final order, it can be an interim order. If there is a sufficient ground to go for appeal and revision, people can go. Okay. And section 32 talks about cognizance and proof. So all the offenses are cognizable. That means court can take up the case on its own if the court observes a DV happening, and all of the this particular one, section 31, is non-bailable. Right? Police can arrest a person if they violate a protection order, and that person will not be granted bail directly. He has to go for anticipated bail, etc., etc. And this, the last subsection, subsection 2, is very, very important. Please read it once or twice. Upon the sole testimony of the aggrieved person. What does that mean? The victim person who got a protection order, if she gives a sole testimony, oral submission to the court saying that my husband has, I got a protection order against my husband, but my husband called me. If the victim says that on orally also, the court may conclude that an offense under subsection 1 of section 31 has been committed by the accused. So accused will not have an opportunity to dispute your testimony. Court will conclude that the person has violated a protection order and he can be sent to jail. Next slide, please. Okay. Once a protection order is passed, it will be in force until the victim person, aggrieved person, applies for discharge of such order. I no longer need a protection order, Your Honor. If something like that, an application is again filed, only then the magistrate will revoke it or the discharge that order. Until then, protection order will remain in force. These are wonderful provisions. Some of them are relevant. Advocates have to invoke them before the court. Right. So I'll skip the remaining part. And this 31 is what I was referring to in the previous slide. Section 31. Penalty for breach of protection order by respondent. If the husband or against whom a protection order is passed, if that person breaches the order, a breach of protection order or of an interim protection order by the respondent shall be an offense under this act. All other things are civil proceedings. This particular act of a respondent is classified as an offense, obviously, which will carry a which is punishable with an imprisonment of either description for a term which may extend to 1 year. So maximum is 1 year, or with a fine which may extend to 20,000 rupees, or with both. So we can't pick and choose what punishment to give to the person, but then court will decide depending on the gravity of the breach. If the respondent makes a call or an email and gives a threat or does any kind of inconvenience to the aggrieved person, court can take an aggressive view on that and put that respondent for maybe 3 months or 6 months behind bars. Court can do that. Okay, and the offense under subsection 1 shall, as far as practicable, be tried by the magistrate who had passed the original order, the breach of which has been alleged to have been caused by the accused. So it is saying that it is all hoping that the case will be disposed in 60 days. That is that 3 months. With that in mind, people are set up this kind of sections. And while framing charges under subsection 1, magistrate may also frame charges under 498A or any other provisions of that code, which is IPC or Dowry Prohibition Act, as the case may be, if the facts disclose the commission of an offense. So, for example, if a respondent calls the victim, aggrieved person, and demands for a dowry, I'm just taking an example. So, automatically, Dowry Prohibition Act should apply. That is what the law says. Next slide, please. Yeah, in this slide, I just listed out the different kinds of reliefs and what are the subsections, sub-reliefs in them. So protection order is possible. I have been talking about protection order. Under protection order, there are some 8 to 9 sub-reliefs. No communication. You should not be going to the place of living of the aggrieved person. If the aggrieved person is a child, you should not go near to the school or college. So there are detailed remedies. So if you read section 18, you will come to know. Residence order. For example, the woman is thrown out of the home. The respondent has to provide residence, which will be equivalent to the residence they used to live together when they were together. For example, they used to live in a 15,000 rupees rented apartment, 2-bedroom apartment. He has to provide at least 1-bedroom apartment to the women, because women may generally have children along with them. So they need more space, right? So similarly, there are other provisions in this act, monetary reliefs. For example, you have certain earnings, there is a job. Because of this case, the aggrieved person lost the job. There is a 50,000 per month income is there, salary is there. You lost it now. So that lost earnings can be recovered from the respondent. Similarly, if there are certain medical expenses, like you regularly take sugar medicine, or like BP medicine, or any medicines, those expenses were used to be borne by both parties when they were together. Now they are separate. Earlier, if the husband was only earning, now there is no earnings to the woman. So she can claim for medical expenses also. Of course, she has to establish certain grounds. I have this medical condition. I need this medication or a treatment from this medical practitioner, and this is the expense, something like that. And loss constitute destruction, damage, or removal of property. We already discussed this in the definition of DV. If a property is damaged or sold off, your two-wheeler is sold off by your husband, you can recover for that loss, and you can buy a new bike. And lastly, maintenance can also be requested, not just for the aggrieved person, but for her children also. Even they will have expenses, maybe school expenses, uniforms, medical, food. If the child is very small, we have to provide for child, what is it? Young toddler food, like Horlicks, etc. So even they cost. And if the child is involved and the child is with the husband, you can pray for custody of that child also. This custody order is a temporary order, because custody orders cannot be granted on this in this act. There is a separate act for it. So here only temporary visitation kind of order can be granted. And compensation, because you have suffered mental torture, emotional distress, maybe physical wounds. So for all those things, you can claim compensation. I remember I told you this is a civil law. So you can claim for compensation. I think all of you will know that there is a suit you can file for compensation or damages. So that you can do this in the act. If you read all these reliefs, you can understand this. These reliefs are actually distinct offenses or reliefs in different acts. What PWDV Act is doing is they are collecting all those things and putting into one act. Okay, and the above reliefs can be prayed for or sought as interim reliefs also under section 23. Okay, for the time being, we don't know how long this case will run. So for the time being, please grant me certain medical expenses, certain maintenance, give me a residence. So these things you can pray for even in the interim for the time being. Next slide, please. Now, advocates, please focus on this. I'm giving a step by steps, more like a handshake, 1 to 2 to 3, step 3, step 4, like that. So at the beginning, aggrieved person or a protection order or any other person on behalf of the aggrieved person can file an application, not petition, not complaint, an application under section 12 directly in the court of magistrate. And along with section 12 application, you can file another application under section 23(1) also, and saying that in section 12 I have main reliefs, in section 23 I want interim reliefs. So you can file 2 applications. And in these applications, in the prayer section towards the end of the application, you can include this also. Your Honor, kindly dispose my matter as per the provision section 12(5), which says 60 days is a time limit. I won't waste the honorable court's time. Please ensure that my case is listed in short times, maybe every week, twice or thrice. I want this case to be disposed within the prescribed time in the law. I'm not prescribing the 60 days. Law says. Along with these two applications, because of certain manipulations and misuse of matrimonial laws, Delhi High Court prescribed a particular format of an affidavit, which is now prescribed by the Supreme Court in Rajneesh versus Neha. It says, give me details of your income, if any, assets, if any, liabilities, if any. So the applicant, the aggrieved person, has to give application under section 12 and application under section 23 and affidavit under as prescribed in Rajneesh versus Neha judgment. Okay, this is the entry point for your for the advocates. These are the documents you have to prepare and file in the court, filing section of the court. Then what happens? The filing section will accept the petition. It will be entered into the different systems are there. One of them is e-courts. They will create a DVC number, DVC 123 of 2022, something like that. And then that filing section will send notices to the respondents through protection order. We just now read that. Section 13 is issue of notice. And that protection officer may talk to the aggrieved person, call them and prepare the domestic incident reports. If you go through the template of domestic incident reports, you will understand it is very simplistic forms. There are a checkbox, fill in the blanks, okay, wherein it will be easy for the aggrieved person to fill it up, or protection officer can fill it on behalf of the aggrieved person also. Protection officer should assist the aggrieved person. Okay, the templates are available in the 2006 PWDV rules. If you want, I have everything on the website. I'll give the links. And then, like I discussed, DRs are not mandatory. We have a Supreme Court judgment. Now comes the notices go to the respondent. It could be husband or anybody in that domestic relationship in that shared household. The respondent gets 4 weeks of time. From the day he received the notice, he has 4 weeks of time to file the counter. Okay, generally what happens in the along with notices in civil matters, the plaint copy should also be sent. Plaint is the complaint. In DV, I don't know if the complaint copy will be, the DV application will be sent because I did not receive. The respondent can appear before the court on the first day and say, Your Honor, I don't have a copy of the application filed by aggrieved person. Kindly give me a copy. So they will give you respondent copies on the first appearance. After that, the respondent will have 4 weeks time to file counter. Counter is rebuttal, denial of the allegations in the application of the aggrieved person. So denials basically, no, this is wrong. Application says my husband did not give me a food. Now the counter says there is a daily food given to the aggrieved person, something like that. So there will be a allegation in the application and rebuttal in the counter. It is otherwise called as written statement of objections, right? A separate counter should be filed to the main DVC under section 12, another one for interim application. Okay, again, respondent also should give the same affidavit that aggrieved person is giving. So both parties are encouraged and enforced to file their true information about their income, salary, assets like properties, vehicles, home, etc., jewelry, and their liabilities, my mutual fund payments, the insurance payments, EMI payments, all those things should come in this affidavit. The template is given in the Rajneesh versus Neha judgment in the end, around 10-15 pages of template. Okay, now a copy of these documents has to be given to the other side also. This is just to respect that both the parties should be on the same page. In legal terms, there is a Latin maxim called as audi alteram partem. That means hear the other side. Don't take a decision without hearing the other side. So in that spirit, the respondent has to give a copy to the aggrieved person, one copy to the court, and one copy he can keep it for his own records. Next slide, please. This particular slide talks about the only interim application disposal. Since it is an interim application, no evidence has to be taken. If you are taking evidence, that means you are running the show of a main case. Correct. If you do the same thing in two things, what is the need of a main case? Then interim application itself should suffice, right? So during interim application, not just in DV case, any case, evidence should not be considered at that stage. Then what should be considered? The documents that we are filing. Applicant, the aggrieved person is filing 2 or 3 documents, right? The respondent is filing 2 or 3 documents. Those documents are the only documents that the court should rely and make a judgment. How to make? Who is more believable? So that is where the writing skills of the advocate comes into picture. Since this is a civil matter, government advocate will not come into picture. Applicant will have her own advocate. The respondent can have their own advocate, private advocates. There won't be any public prosecutor in this PVC cases, right? So these 4 documents have to be submitted to the magistrate one after another, and the magistrate has to rely on those 4 documents, the content in them, and then take a decision whether interim application has to be allowed or not. If it has to be allowed, to what extent? For example, in the interim maintenance application, a wife will be claiming 50,000 rupees per month. But then the court may think only 15,000 rupees, 15,000 is sufficient for her sustenance. So court may grant any other order. Okay, so this is how courts have to dispose. But many courts violate this fundamental principle. They even take evidence. They do examination, chief examination, crossing, all those nonsense things they will do. That is wrong. If you see such kind of thing happening, you have a duty to make a complaint to the district judge and get that magistrate kicked out of the court. That is the right thing to do. If you don't want to get into argument with the judges and all. Next slide, please. Now, similar to the interim maintenance application, but here evidence stage, examination stage, cross-examination, all these things come into picture. Please pay attention here. After filing of counter, both parties are on same page. The woman has filed something into the court, the husband has filed something into the court. Now court wants to examine, right? In the examination stage, you can give evidence. That's why I mentioned examination and evidence stage. The married woman, the aggrieved person, has to give a list of witnesses to the court. Your Honor, these are the people who are going to support my version of the story, right? This will give an opportunity to the respondent to prepare how to handle these respondents when the cross-examination happens. Okay, it's more like upfront notice. After giving the list of notice, what happens? Chief examination of the victim woman happens. It can happen orally after providing oath. I missed that step. Oath passed is I missed totally here. After taking the oath from the aggrieved person, chief examination will be taken. Chief examination can be oral, as in the witness will sit in the dock. Her own advocate will make some questions to the aggrieved person, saying that why are you here in the court? Who are you? Okay, you said domestic violence. Can you explain what happened to you on a day 1, day 2, during marriage or during whatever? Right? That is one way. Second thing is, in the interest of saving time these days, or making some mistakes while speaking, advocates are filing affidavits saying that this is what the stand of my client is. Okay, affidavit. Then comes the crucial stage of cross-examination of aggrieved person. So the funda is like that. Chief examination of a witness happens. Immediately after that, cross-examination of the same witness happens. If there is a second witness, after the cross-examination of the first witness, chief examination of the second witness happens. This is more like train compartments. One is attached to the another. All examination of one witness should complete before second witness can be taken up. Okay, so that is the sequence. Don't get confused. Please don't get confused here. And again, in technical terms, we call the witnesses from the aggrieved person side as prosecution witnesses, PWs, PW1, PW2, PW3. Similarly, if the defense, that is the respondent husband side, if they have a witness, if they want to submit to the court, they will be called as defense witness 1, 2, 3. Okay, I skipped all those things just to keep it light. If your cross-examination did not happen as per your understanding, but unfortunately for whatever reasons, you said my cross-examination of aggrieved person is completed. But then you realize, no, I have further questions. That will be difficult because you have to convince the court that this is the reason I could not properly examine the witness. I want the witness to come back. Okay. And at each stage, if once the PW1 comes to the dock, there might be an audio recording, a photograph, a medical certificate, bank statement that the witness wants to support. So at that stage, the advocate can move the document or audio, video, whatever it is, to the court and say, Your Honor, kindly mark this exhibit. Okay, mark this evidence as exhibit. Each audio recording, photograph, all these evidences will be marked as EXB exhibit dot P1, EXB dot P2, EXB dot P3. Sequential order. Okay. Similarly, once the chief examination, cross-examination of the aggrieved person side is completed, then comes the respondent side. So now coming to the respondent side, the defense side, if the defense conducts the cross-examination, let me remind you, defense conducts the cross-examination of the aggrieved person. From their own understanding of the cross-examination, if the cross-examination is successful, that means defense party has already made sure that the complainant herself ruined her case. Okay, if that is the case, defense party will not go forward with witnesses, their witnesses. They will say, she has screwed up her own case, she has damaged her own case. There is no necessity for me to bring any evidence. Okay. Unfortunately, if the cross-examination was not able to successfully completed, then the defense party may want to bring some new information to the court. Your Honor, she has brought her evidences. Give me opportunity to give my evidence to the court. Okay. So then again, chief examination of the respondent number 1 happens. Cross-examination of respondent number 1 happens. If that is done successfully, chief examination of respondent number 2 happens, and then cross of respondent number 2, something like that. And they can also produce or submit their evidence to the court at this stage. I hope I'm making it easy for you. And if you are unable to follow my session, there is a detailed stage-wise explanation given in the link at the footer. You can go through. Next slide, please. So this is the last slide. Here, after the examination and evidence, the court has sufficient information before it. Now, each of the advocates get an opportunity to argue. So generally, in a sense, we say argument is between people. No, in this case, arguments are submitted towards the court. If you see in movies and televisions also, wherever the court scenes are there, generally advocates talk to the court. Your Honor, my client should get reliefs in the DV case because 1, 2, 3, 4, 5 reasons. Once the aggrieved person advocate completes, submits his oral arguments, they can file a written arguments also. Okay, same cause title, you can say, most respectfully sure, it is submitted that. So you can write arguments also and give it to the court. Once the petitioner side, the complainant side arguments are completed, the defense advocate gets an opportunity to argue. Likewise, they can rebut one another's arguments until they don't have any further to argue. Once their arguments are done, their rebuttals and denials, etc., and they can use judgments also to support their argument. Once arguments are done, court will say, okay, all the procedure is completed. It is time for me to take some time and write the judgment and come back and announce it. I have written a couple of steps for that. Okay, and then we can go for appeal if you are unsatisfied with the judge's decision. Okay, so I have very quickly ran through this. If you want, please go through slide number 11 to 14 again and again, right? Just to understand the sequence. Once you understand the sequence, friends, let me tell you, it doesn't matter DV case, it doesn't matter 125 CRPC case, diverse case, 498 case, procedure is same. The game they play in the court is same. Sections will differ, but the game will be remaining same. Okay, sections here 12 and 23. In a criminal case, in a 498 case, sections will be a little different. There are like 500 sections, 400, 500 sections. So I want to conclude by saying, unless you go through these slides once or twice right after this session, it will be difficult for you to recollect what is the of a life cycle of a DB case. Thank you, friends. If you have any questions, let me know. I'll try to answer. If there are no questions, I have certain tasks to you in the last slide. Priya, can you go to slide number 15, please? So please, you have a good amount of team. Some people are active, some people are inactive. It's okay. Do a role play. We know there is a agreed person. We know there are respondents. We know there are advocate for agreed person, advocate for respondent person, and we know there is a judge. So at least 5 people can do a role play. It's more like a drama kind of thing, and take each role just like we used to do in our colleges, like mock trials, right? Try that. Then you will understand how each person in the courtroom will behave and talk and get relief to their clients, right? And once you come up with a chief affidavit template, cross-examination questions, argument, how to argue, discuss with people that you love and trust and believe can help you, right? So those are the 2 things that I suggest you try. Any questions, please?
Thank you, Sandeep. Sandeep, this is really helpful. I mean, for a person like me who didn't do law, even then, I was able to understand, I mean, the flow, and then what are all things that I am capable of doing after going through so much of abuse. So it actually gives a kind of strength to any victim.
Yeah, one of the ideas is to make it so easy for anybody, advocates or non-advocates, especially for advocates, that it should not cause any panic in them, any worry in them. There is nobody going to be hanged in this. Nobody is going to prison. Everything has a reverse button in this. It is easy.
Yeah.
If nothing is working, we can drag the case to the appellate court in the sessions. So I want to make it as easy as possible. And frankly speaking, these laws are easy. That is why I picked the family law. I'm trying to target narrowly, address certain claim. And if it is helping non-legal persons also, I think I'm successful in my goal.